Dealership sold me a wrecked supercar as new, so I used the Magnuson-Moss Act to bankrupt their service department. This is the story of how a car dealership tried to hide a massive wreck and sell me a $150,000 sports car as brand new. They thought their arbitration clause would protect them, but they forgot about the Magnuson-Moss Warranty Act. That mistake cost them their service department. I saved up for years to buy my dream car, a highly specialized, high-performance sedan. I bought it from a reputable dealership specializing in European luxury brands. It was listed as certified pre-owned with a factory warranties still active. I paid $150,000 cash. 3 weeks later, the trouble started. The car kept pulling hard to the right. Then the electronic suspension failed on the highway, and the car started making a terrible grinding sound. I immediately took it to an independent performance shop, not the dealer. The mechanic there called me back with chilling news. This car wasn't just in an accident, it was totaled. The repair shop showed me the evidence. The frame had been welded back together with non-factory parts, the paint was mismatched under the hood, and the airbags had been deployed and restitched into the dashboard. A massive fraud. They had purchased a salvage title car, fixed it cheap, and sold it to me as perfect. I confronted the dealer. They were arrogant. The general manager, Gary, pointed to the contract. Your warranty only covers mechanical failure, not pre-existing conditions, and look here, you signed an arbitration clause. Arbitration clauses force you to settle disputes privately, which usually costs the consumer time and money and shields the dealer from public liability. Gary thought he had won, but I hired a specialist in lemon law and federal warranty litigation. My lawyer ignored the state-level lemon law and went straight to the nuclear option, the Magnuson-Moss Warranty Act, 15 U.S.C. 2301. The Magnuson-Moss Act is the secret weapon against warranty fraud. It states that if a dealer violates the terms of an express or implied warranty, and if that violation rises to the level of fraudulent misrepresentation, the dealer is liable for damages. But here's the killer. The act forces the defendant, the dealer, to pay all of the plaintiff's legal fees if the plaintiff wins. This turned my $150,000 loss into a potential $350,000 liability for the dealer when we added punitive damages and attorney's fees. We sued for the full return of the purchase price, the cost of the third-party inspection, punitive damages for the intentional deception, and, critically, our legal fees. Gary realized his arbitration clause was useless against a federal claim of fraud. Their insurance company panicked. They knew if the case went to a jury, the emotional factor of the intentional deception would lead to a massive punitive award. The dealer settled 1 day before the court date. They didn't just give me the money, they were forced to buy back the car at the full $150,000 price, pay my lawyer $90,000 in fees, and pay $50,000 in punitive damages. Total cost to the dealer, $290,000. The dealership had to sell off assets from its service department to cover the settlement. They learned the hard way. Trying to hide a wreck violates federal law, and when you violate federal law, your arbitration clause is just an expensive piece of paper. Car dealers often use arbitration clauses and legal complexity to protect themselves after committing blatant fraud. My question is, should state law immediately revoke the dealer's license after one proven case of selling a salvage car as new, or is a massive financial fine enough punishment? Tell me your thoughts on how to stop dealership fraud in the comments.